So in Melendez Diaz versus Massachusetts, the court had to ask the question of whether a lab report that indicated something was cocaine was in fact consistent with whether the admissibility of that as a business record was consistent with the Confrontation Clause. And the court said no, because if anything is prepared in anticipation of litigation, it would be something like a forensic analysis, like a lab report. So in order to introduce this report, you'd have to have the person come and present it and describe what's in it. And so Melendez-Diaz versus Massachusetts lays out this first step, that consistent with the Confrontation Clause, you cannot have like a certification from the custodian of the records of the Massachusetts Forensic Laboratory that we examined the samples that were sent to us and it is in fact cocaine. You have to have someone come from the lab and say, did the test, this is what it is. That the testing agency or the testing agent has to be available for cross-examination if it's a criminal case against a defendant. Now, what about in Bullcoming? In Bullcoming, you didn't have the lab agent himself who did the test. You had someone who could testify to how the officer in the lab went about it, someone who himself does these tests. And this particular witness says, so here's how it works. You put the gas sample, it's a DUI case, you put the gas sample of the breathalyzer into the chromatograph machine. Put the gas sample in the chromatograph machine, and it does its thing. This is how it does its thing. And at the end, it'll give a number, and the lab technician who put the gas cylinder into the machine simply will record the number. And that's how it works. And this is the number that apparently the lab tech wrote down and put in the report. So there you go. And the question in Bullcoming was whether this particular witness, who didn't actually conduct the test, could the witness describe what any lab tech would have done under this circumstance, or does it have to be the actual lab tech himself or herself? And in Bullcoming, the court says it has to be the actual lab tech, that otherwise this is still hearsay, that you're not actually describing what was being done. You're just coming in as a fancy custodian of the records. Rather than having someone who keeps the files, you're having another scientist come in and say, here's the file the other guy kept, and this is how he wrote it down. That this is not good enough for the Confrontation Clause. It might be a business record, but it's not good enough for the Confrontation Clause. Now, why is that problematic? I mean, so, obviously that puts a burden on the prosecution. That means that as a practical matter, in cases that involve forensic evidence, it will be more difficult for the prosecution to make these cases, particularly in small communities where there may be only one or two cases a day that involve forensic evidence, and there might be only 4 or 5 lab technicians. You have to send these folks out, depending on how many lab techs you have, how many forensic offices you have across the state. It might be there's only one office, and it might be on the other end of the state, and you have to send someone to testify in all these cases. So it creates a financial burden on the prosecution that will encourage the settlement of cases. So it's bad for the prosecution in a way, in that actually in every way, in that it expends resources. It makes it more expensive to have a criminal trial, and so therefore the plea bargains become more generous because the prosecution has a greater incentive now not to actually have these trials. But could this actually be problematic for the defense as well? And I think the answer is yes. Ultimately, it is. And here's why. So take a look at Bullcoming. Now, in the New Mexico case, Bullcoming versus New Mexico actually had a statute that said that if you did one of these breath samples, you had to preserve enough of the person's breath so that sample would still be available to the defense to retest. And that's great. I mean, if you get to retest the sample and you claim it's not accurate, well, let's retest it and find out what's there. But not every state has this statute. And so here's what's really interesting about the road that Scalia and this originalist doctrine takes us down. The court says, in Crawford, this is not about reliability, this is about procedure, and it's about the procedure the framers gave us. Reliability has nothing to do with this particular concern. Well, as technology increases, then in many ways, it makes more sense to have a scientific check rather than a judicial cross-examination check on the accuracy of information. So think about Bullcoming, for instance. It's actually possible that the lab tech in Bullcoming was lazy and had done a bad job. This lab tech was on unpaid administrative leave. It's possible that this person is not doing a careful, thoughtful job. It's even possible, even worse, that this lab tech has been caught intentionally skewing data to help the prosecution. Things like this have happened with lab techs. It's not common, but it has. So, on the one hand, we say, well, we get the lab tech in, we find out if we get to cross-examine this person. Hey, wait a second, isn't it the case that you've been charged with previous malfeasance in this job? And that would undermine the lab tech's testimony. Sure, no question about it. But also undermining the lab tech's testimony would be a retest of those air samples that shows the person wasn't actually intoxicated. That would be even better. I mean, if you've got your choice as a defendant, if you say, I wasn't drinking that night, and I say to you, which of the two would you prefer? Would you prefer to call the lab tech and cross-examine him on the fact that he actually is under investigation for faking results? That's good. Or would you rather get to retest the samples? Since you say you weren't drinking on that occasion, would you rather retest the samples and see what the actual blood alcohol content is in those air samples? If you actually haven't been drinking, retesting the samples is much, much better. Now, under New Mexico law, you could do either because the statute allows you to retest. And now the Confrontation Clause says, according to the Supreme Court in Bullcoming, you got the right to call as a witness the person who actually did the lab test. And if that person has some shady history, you get to cross-examine that tech on that shady history. But what about this? What about a world in which the statute hasn't been written, as it hasn't in several states? New Mexico is part of the progressive movement on this issue. What if we were asking the question under the Confrontation Clause, not about procedure, but about reliability? What if we thought that the Confrontation Clause only allowed in reliable evidence, super reliable evidence, when we're talking about a criminal defendant? Well, super reliable evidence might well be forensic evidence that you had the opportunity to retest. If we viewed the Confrontation Clause as being concerned about reliability rather than procedure, the judicial opinions on the Confrontation Clause might well require states to adopt all states to adopt what New Mexico has adopted. As it is now, whether they adopt these reforms or not and enhance reliability, either way, now they're going to have to provide enough money for their lab techs to come and testify in the most remote parts of the state. Are they also going to be willing to spend money to provide for retesting of the lab samples? And as between the two things that the court could incentivize with its Confrontation Clause litigation or decisions, would we prefer, for the sake of the right outcome in criminal cases, would we prefer to have an opportunity to cross-examine the lab tech about possible historical examples of bad tests he's done, or actually know what's in those samples? So here's my problem with the way that the Supreme Court has done the Confrontation Clause analysis. As Justice Kennedy says in his dissent in Bullcoming, the majority actually rejects the idea that reliability is what we're going for. That's a strange statement in and of itself. In rejecting reliability as the basis for these decisions, you have then rejected the court's ability or denied the court the ability to do things that will enhance the accuracy of criminal trials. You created procedural niceties that may on occasion cause a jury to get the right answer, that they'll reject evidence in cases where there are bad employment records by the bad employment histories by the lab techs, but it won't do anything to actually show whether this particular sample was legit or not, was properly tested or not. The statutes, like the ones that New Mexico has, those actually give us a chance to find out what was in those actual samples. And if we had a confrontation clause that the court still said was worried about getting the right answer, rather than engaging in procedural niceties that Scalia believed the framers thought we were required to do. And I didn't give you the whole opinion, but I'll tell you, there's definitely some wiggle room. There's definitely some room for interpretation on that view. But the idea that we're supposed to do exactly what the framers thought, even though that's really unclear, that will yield us answers that are not necessarily reliable, but give us procedural niceties, as opposed to the rule we had before Scalia changed the Confrontation Clause rule, that was driven by reliability, that could force states to have more accurate testing and better opportunities for retesting. That was the choice that was made in Crawford. And in Bullcoming, we kind of see this whole thing finally come full circle. We're not worried about reliability. And so if states want to retest or give that opportunity to defendants, that's fine. But as for us in our Confrontation Clause jurisprudence, we don't really care if you get the answer right or not. We just want to make sure you use the right procedures. Even if there were procedures that would better ensure the accurate answer, that's not the goal of the Constitution. Think about how bizarre that is. But that is Bullcoming. Bullcoming says that lab reports are not exceptions to hearsay, even though, as Justice Kennedy says, you could call people, you could actually call this witness himself. You have the compulsory process as a defendant. You could call witnesses to say, sometimes these lab results are fake or bad. You can call the lab analyst yourself if you wish. But the Supreme Court says the prosecution has to call the lab tech who did the test for it to be admissible, and I think more importantly, because it's not about reliability. If states want to provide the opportunity to retest, that's not anything the Constitution has anything to say anything about. But it has everything to say about a superfluous need for the prosecution to call the lab tech on its own, that the failure of the state to call that lab tech negates its ability to bring in this information. And so they have to do it. But the basis of that rule then says nothing about the requirement for the state to do what New Mexico has agreed to do through its statute. And that's not the way that the law will now advance. So key takeaway, even though it's real clear what the lab tech is going to say, I put it in the machine and the machine said 4 and I wrote down 4. That's it. The person who did that test, the person who actually wrote down that 4, now has to come and testify. But you don't have to provide the opportunity to retest the sample, which would in fact be more likely to give us the right outcome.